All right, welcome back. I've got an interesting one for you today, I hope. So, unfortunately, this isn't, at least the first half, isn't going to be our normal funny sovereign citizen video because, frankly, there's nothing funny about it. This is the occasional reminder that for all the funny videos we get, the sovereign citizen ideology is at its core a dangerous one. And yeah, it's a dangerous one. So we're gonna take a look at a few news articles. No video for this one yet. I'm going to put in a public records request, try to get this. So let's keep our fingers crossed that I'm able to get video in the near future. So this is one you should all send thanks to my mom. She actually put me in the direction of this one, although I kind of saw this first article on Wednesday, the 1st. Unfortunately, it was updated on the 2nd, so the exact article I saw. But there were a few things that kind of got my brain, wondering, could this be a sovereign citizen? But there wasn't enough information. So the it's from the Salt Lake Tribune, so it's local here. Man shot by Farmington police after traffic stop Wednesday dies. And I don't think this subheading was on the original article. It says the man actually pulled over by sight, he said. Um, and we see this picture, bullet holes in the windows of the blue sedan. And what the thing that actually made me curious when I first saw this article was it happened in a post office parking lot. So I realize post offices are more First Amendment auditors, which aren't necessarily sovereign citizens, although many of them are, or at least they espouse the sovereign citizen ideology sometimes. But it still was enough to get the, synapses firing and wondering what was going on. So while this is the article that first got me thinking about it, we're going to look at today's article. This is the young man that was shot and killed by the Farmington police. Chase Allen, who is 25 years old. Uh, Once again from the Salt Lake Tribune, police shooting of Farmington man called brutal murder by family. Less than a day after the man's family released a statement, Farmington police released new details Friday on the fatal police shooting. So this is a case, like I said, there's no video yet. So I'm not going to pass judgment one way or the other. It's unfair to both the police and to Mr. Allen. But that being said, from the information that I've seen, I have a feeling this is the ultimate reflection of the mantra, fuck around, find out. It's, I think this kid, as you'll see, he didn't stand a chance. You look at nature versus nurture, this kid didn't stand a chance. So we'll look through the article, but then the article will show his mother is also a sovereign citizen. And lucky for us, We don't have video of her traffic stop either, but we do have filings from her federal civil rights lawsuit. So we'll take a look at that. Uh, um, and I'm going to try to get video of her traffic stop. So he's standing in front of wisteria. We can see that little purple flower there. That's one of my favorite vines, just as an aside. So, taking a peek at the article by Scott D. Pierce and Jordan Miller of the Salt Lake Tribune. Farmington police released new information Friday about a police shooting Wednesday that left 25-year-old Chase Allen dead. The update came less than a day after the family of Allen accused the 5 officers who police said opened fire on him of brutal murder and said they were being stonewalled by the police department. The police shooting unfolded Wednesday in the parking lot of the Farmington Post Office, located at 145 East State Street. Police had initially said that a Farmington officer pulled Chase Allen over that afternoon because he was driving without a license plate, and said the officer called for backup when Allen became non-compliant. 4 more officers arrived, and when Allen refused to get out of his car, police said they tried to remove him from the vehicle. A confrontation ensued, and shots were fired by the 5 officers, according to police. At the time, police had not said whether Allen was armed. In a statement released late Thursday, Allen's family disputed the initial police version of what led up to his death. Officers claim it was a routine traffic stop, yet the officer requested multiple other officers to the scene a couple blocks prior to the stop, according to the family statement, which does not cite the source of that conflicting information. This resulted in the brutal murder of Chase at the hands of 5 Farmington police officers, with them shooting him while he was still in his automobile and likely terrified for his safety. And you notice it wasn't a car. I'm surprised that they actually called it an automobile even. I would have expected vessel or conveyance or something. Um, they shot 12 plus rounds at him while he was still inside the car with the engine running and lights on when reporters arrived, the family statement continued. But the police released updated information on Friday. Um, and for your information, it's 11:30 p.m. on Friday right now, so that's today. On Friday afternoon, Farmington Police Chief Eric Johnson released a statement with more information about the police shooting, noting that the officer who pulled Chase Allen over on Wednesday afternoon did so because Allen was driving with an illegitimate license plate. The statement did not describe the illegitimate license plate. So let's guess what it is. I'm sure if I'm able to get the video, we'll see it eventually. So is it not not for hire, not commercial, UCC 1-308 or 9- whatever? Is it the private plate? Is it sovereign? Is it the state national plate, the Anna von Reitz plate? But take your guess. According to Johnson's statement Friday, which cited body cam video of the content viewed, but has not yet been released to the public, Allen then pulled into a parking stall at the Farmington Post Office and rolled down the window of his blue sedan only a few inches, refusing to provide identification or cooperate with the officer. Johnson said Allen asserted his independence from the laws of the land in the video and stated that he was not required to provide information to the officer or cooperate. The officer then called for backup, Johnson said, and continued to provide the driver with information and options, but to no avail. The 4 officers who then arrived included a supervisor, two officers, and one police trainee, Johnson said. Together, they ordered Allen to exit his vehicle. When he refused, one officer opened the door to Allen's car while another officer attempted to remove him, according to the statement. In the body camera footage, according to the statement, an officer can then be heard yelling the words, "gun, gun, gun." It's unclear which officer shouted the warning, but Johnson said a struggle ensued, which lasted only seconds before police opened fire. As authorities began rendering aid to Allen, Johnson said an empty holster can be seen on Allen's right hip in the unreleased body camera video, and a handgun can be seen lying on the driver's side floorboard. Johnson did not say whether Allen brandished the gun or fired his weapon. No passengers were inside the vehicle, and no officers were injured. Allen was taken to a hospital where he died. It's unclear if any bystanders were in the post office parking lot at the time of the police shooting. In their statement released late Thursday, Allen's family accused Farmington police of not reaching out to them about the police shooting and refusing to release more information to them. Um, so this is all about whether or not they contacted him. I don't really care about that at the moment. Um, Johnson said Friday that the Davis County Critical Incident Protocol Team is investigating the police shooting. That team has provided liaisons to both Farmington police as well as Allen's family as the investigation continues, he said. Video footage is only one part of the complete comprehension of the incident, and we recognize that our understanding of the incident may change as more information and evidence is gathered and analyzed, Johnson said Friday in the statement. We don't draw any final conclusions regarding the actions of the officers until the protocol investigation has been completed. Um, Allen's family claims he was a patriot who defended freedom and liberty. Allen's family said Thursday that he was a gracious, loving soul who was known by everyone in his community to be caring, thoughtful, and kind, and would do anything for someone in need. The 25-year-old lived in Farmington with his parents. A graduate of Davis High School and Utah State University, Chase was a son, brother, grandson, nephew, peer, teammate, student, and neighbor, amongst many other important roles he played within our community. The family statement went on to say that Allen was always selflessly helping and protecting others in need. He has been studying the law the last few years and was a patriot, doing what he could to defend the people's freedom and liberty in his community. Now, this is where we get into more past information, the interesting stuff. So, local court records show no recent criminal history for Allen. But according to a probable cause statement on September 21st, 2022, Allen voluntarily showed up at a Davis County Justice Court hearing for a woman who had been charged with a traffic violation. During the hearing, Allen became disruptive and non-compliant and began to resist officers, the document states. He refused to comply when told to leave the courtroom. Now, I kind of have a feeling that this was his mother's court proceeding, but we'll get to that in a little bit. A Davis County Sheriff's Office deputy wrote that reasonable force was used to arrest Allen and that he was taken to the Davis County Jail. The probable cause statement goes on to say that while he was being booked, officers found Allen had a small plastic slide credit card device that contained several lock-picking items. According to police, Allen matched the description of an individual with warrants, but he refused several requests to identify himself. When asked to stop interrupting, Allen responded that deputies had no authority over him, using an expletive, the document states. Allen was released on his own recognizance, agreeing to appear at future court proceedings and to not commit any crimes. There is no record of charges being filed against Allen. That's a mistake. If sovereign citizens commit crimes, they always have to be charged, they always have to be prosecuted. You can never show them an inch. Otherwise, they take it as a win, and it just leads to more nonsense. You've got to nip it in the bud right at the start. Shooting by March the fourth police shooting in Utah so far this year, according to a database maintained by the Salt Lake Tribune. The third and otherwise most recent police shooting in Utah happened on January 29th in Iron County when authorities shot and wounded a reportedly suicidal woman who police said was armed inside a van and refused to exit. She was later charged with several felonies. So that's what we have from the Salt Lake Tribune. But let's take a look at his mother. And let's see, I want that first. So her case, Allen versus Hansen et al., is in the district court, federal district court for the District of Utah. And it's ongoing. It was filed September 9th of 2022. So let's actually go back to the article, September 9th, 2022. Let's see. Well, the probable cause statement says that it was on September 21st, 2022, that Allen voluntarily showed up at the Davis County Justice Court. Hmm. Hmm. Oh well. Just the same. So it could be that I'm reading a update. Uh, I'm having a mind blank here. But a revised complaint. So that being said, the first thing I'm going to take a look at is the newest docket entry from February 3rd of this year. And the reason it's the first I'm going to look at is it gives us a little bit of an idea what kind of sovereign citizen we're dealing with. Um, because as we know, sovereign citizens love their affidavits. They love them. They'd marry their affidavits if they could. Um, and this one, I do think gives us a good idea of what we're looking at. And so this is affidavit declaration of Diane Killian Allen in support of docket number 57, motion for summary judgment filed by the plaintiff. Newsflash, she's not going to have her summary motion read. So as I said, this is affidavit in support of notice for summary judgment, as opposed to motion for summary judgment. It's a notice for summary judgment because sovereign citizens somehow think, they don't have to move for something. They can give the court notice that, here's your notice that you have to give me summary judgment. And for those of you who have followed the Brunson versus Adams case that I've covered, you may remember in the very first video from that, I discussed it was heard, well, it was initially filed before a federal district court judge. Then it was chucked off to a magistrate court judge and then chucked to a different magistrate court judge who dismissed it. This is being heard by Magistrate Cecilia Romero, who was the first magistrate that was in charge of Brunson v. Adams. So, little continuity for here. So we have I, Diane Killian Allen, am the named claimant, consumer above, and state and swear before good, under penalty of perjury, under the laws of the United States, that the following is true and correct to the best of my knowledge. 1. I am over the age of 18 and am competent to testify before this court. 2. I am the harmed claimant slash consumer in the above titled case, and I am familiar with the files, records, and pleadings in this matter. 3. The facts forth in this petition are true and correct to the best of my knowledge. And then we just get into a block quote. Without prejudice, UCC 1-308, old UCC 1-207.4, this woman reserves all this woman's rights not to be compelled to perform under any commercial contract or agreement that this woman did not enter knowingly, voluntarily, and intentionally. This woman does not accept of any compelled offered or non-disclosed commercial contract or agreement offered. All offers accepted pursuant to 40 Stat 411, Section 7E, and 50 U.S. Code 4305B2. This is a legal permanent fixture and part of every page of this tort claim petition in this court of record in exclusive common law of England that shall be read and considered in every court pursuant to all laws, non-assumptive, without recourse. UCC 1-103.6 by Ezekiel 18:30. Therefore I will judge you, O house of Israel, everyone according to his ways, saith the Lord God. Repent and turn yourselves from all your transgression, so iniquity shall not be your ruin. Hosea 4:6. Now, I'm not religious at all. As I've said, I grew up Mormon up till I was 18. I'm unfamiliar of the book of Hosea. But apparently there's a Hosea 4:6. My people are destroyed for lack of knowledge, because thou hast rejected knowledge. I will also reject thee, that thou shalt be no priest to me, seeing thou hast forgotten the law of thy God. I will also forget thy children. And Matthew 25:16. For the kingdom of heaven is as a man traveling into a far country, who called his own servants and delivered unto them his goods. And then we have, unfortunately, this is a scan in black and white. I'm going to assume that this is red ink at a 45-degree angle, saying by Diane Killian Allen over a 2-cent US stamp. Submitted this 3-day in the year of our Lord, February 2023, by Diane Killian Allen, and notarized because, well, I mean, affidavits do need to be notarized, otherwise it's a sworn declaration. But sovereign citizens believe that an affidavit, even though an affidavit just has the, power of showing it was signed by who it is alleged to be signed by, sovereign citizens somehow think that it gives the force of law to a document somehow, I guess. And then scrolling down, it has the same statement and the same religious quote certificate of service. So that one was fun. Um, but that one doesn't give us all the information, but I think it does give us at least a basic idea of what flavor of sovereign citizen we're dealing with. With that said, let's take a peek at the complaint. And this is in the United States District Court for the District of Utah. Diane Killian Allen, plaintiff, versus Dane Hanson, Eric Johnson, Wayne Hanson, David Cole, Troy Rawlings. That's the district attorney for Davis County. John Carl Yanchowski, who is the Justice Court judge. I've never appeared before him, so I'm not completely sure how to pronounce his name. Farmington City, Davis County Attorney's Office, Davis County Justice Court, and Davis County Drug Court. And this is a petition and request for emergency preliminary injunctive relief and well, ampersand and petition for declaratory judgment and verified claim for damages. And as I mentioned, it's before Magistrate Judge Cecilia Romero. Trial by jury demanded. Petition and request for emergency preliminary relief, blah, blah, blah. So now comes plaintiff Diane Killian Allen, hereinafter referred to as Allen or plaintiff, in this court of record, being one of the sovereign people of Utah, neither in the capacity as a citizen of the state of Utah nor as a citizen of the United States, and files this request for emergency injunctive relief and original petition for declaratory judgment and claim for damages to freely exercise her right to a trial by jury in a suit at common law guaranteed to her by the Seventh Amendment to the United States Constitution. Plaintiff will show that she was subjected to deprivation of rights under the color of state law secured by United States Constitution and Utah Constitution. Plaintiff will show that said deprivation of constitutionally secured rights amounted to predicate acts practiced and participated in by all defendants who are public servants who violated their sacred oaths of office and who exceeded their scope and authority granted to them by we the people. This action is brought pursuant to 42 USC 1983 to redress the deprivation under color of law of plaintiff's rights as secured by the United States Constitution, complaining of defendants Dane Hanson, Eric Johnson, Wayne Hanson, Troy Rawlings, David Cole, John Carlin Chowsky, Farmington City, Davis County Attorney's Office, and Davis County Justice Court, respectively, and for cause of action, would respectfully show unto this honorable court the following injunctive relief. Parties. The plaintiff, Diane Killian Allen, hereinafter plaintiff, is a private citizen of Utah State, in quotation marks, and owns a piece of land situated within, but outside the limits of and jurisdiction of the state of Utah and can sue or be sued. The defendant, Dane Hanson, in his private and official capacity, is a citizen of the state of Utah and can sue and be sued. And then it says the same thing about Eric Johnson, Wayne Hanson, Troy Rawlings, for the flow, Cole, David Cole, John Carl Inchowski, Farmington City, and other parties, is a political subdivision of the state and can be sued and be sued. Defendant Dane. So, on information and belief, defendants Dane Hansen, Eric Johnson, and Wayne Hansen are or were at the time of the events complained herein employed by the Farmington City as police officers or acting under the authority and orders of the Farmington City and Farmington Police. The Farmington City is a political subdivision of the state, in quotation marks, of Utah within the District of Utah. On information and belief, defendant John Carl Yanchowski is or was at the time of the events complained of herein employed by the Davis County Justice Court, doing business as Davis County Drug Court Inc. Except it's not a Inc. It's not a it's not a corporation. Yeah, silly sovereign citizens. On information and belief, defendants Troy Rawlings and David Cole are or were at the time of the events employed by the Davis County Attorney's Office. At all times material to this complaint, the defendants were acting under the color of state law, ordinance, and or regulation, statutes, custom, and usage of the Farmington City Police, Davis County Justice Court, and Davis County Attorney's Office. The Davis County Attorney's Office is a political subdivision of the state, in quotation mark, of Utah within the District of Utah. The Davis County Justice Court is a private for-profit corporation doing business as Davis County Drug Court Inc. Wrong. It amazes me. I mean, we talk about corporate fictions. This is all fiction made up by the sovereign citizen. But as to venue, on information and belief, all parties are either reside in or are a political subdivision of the District of Utah, State of Utah, and the events giving rise to the claims asserted herein occurred within said district. Therefore, venue is proper. That is actually correct. Jurisdiction. This court has subject matter jurisdiction over this case pursuant to Title 28 U.S.C. 1331. That means it's federal question jurisdiction. As this action arises under violations of the First, Fourth, Fifth, Sixth, Seventh, and Ninth Amendments to the United States Constitution by named defendants under Title 28 U.S.C. 1343 A3, in that it is brought to prevent imminent deprivations under color of state law of rights, privileges, and immunities secured by the United States Constitution under Title 28 U.S.C. 1343 A4, in that it seeks to recover damages and secure equitable relief under an act of Congress, specifically Title 42 U.S.C. 1983, which provides a cause of action for the protection of civil and constitutionally secured rights, Title 2201 and 2202, to secure preliminary and injunctive relief from imminent deprivations of plaintiff's right in property. Plaintiff is not a member of the BAR Association, so she's of the belief that it's not the bar, it's the British accreditation or accredited registry. So, yep, that sovereign citizen for you right there, BAR Association, and is proceeding in propria persona in this action. Furthermore, the courts have held that action that is brought by sovereign individuals is not to be held to the same high standards as action brought by licensed attorneys. All that is required is that the pleading be in a format that any reasonable person could understand, which this pleading conforms to. Facts of the case. Plaintiff is one of the people of Utah State. As such, she is guaranteed certain unalienable rights which are guaranteed to her by the United States Constitution and the Utah Constitution. At all times during the course of this action, These rights were in place for the enjoyment of the plaintiff, as all are equal under the law and under the eyes of God. Exhibit 3, Citizen's unrebutted affidavit of truth and unsigned rescission citation is included by reference as though fully stated herein. Funny enough, you don't have to rebut or do anything with their affidavits. I mean, sovereign citizens seem to think I present this affidavit. If you don't rebut it, that means it has the force of law and you forfeited all rights to contest it and blah, blah, blah. But no, you've got to respond to her motions. Her affidavit's not a motion. And I mean, unless unless it's from some other court case, what is it? I mean, I'm assuming it's exhibit 3 to this complaint. So, well, number 1, they don't have to rebut it, but why would it be rebutted? It's being filed as evidence, and I use that very loosely, evidence in support of this complaint. The complaint is what will be rebutted by the answer. It's that simple. Except this could be, it's the affidavit of truth, rescission citation. Um, so I'm wondering, I haven't seen it. I'm wondering though if this is her um affidavit of truth that, sovereign citizens send to the sheriff or to the DMV or to whatever state agency before they're pulled over, saying, I'm not part of society. You've got to leave me alone. Nah, nah, nah. I don't know, but we'll see. Defendants, I'm just going to refer to them collectively as defendants, have violated plaintiff's constitutional rights and continue to maliciously prosecute plaintiff for unconstitutional codes and statutes, both in quotation marks. On or about April 7th, 2022, plaintiff was traveling in her private automobile in the geographic region known as Farmington, Utah. Plaintiff reasonably expects to be able to access the public roads without her liberty, in capital liberty, restrained, as this is an inherent right. Non-emergency use of emergency vehicle lights and sirens is a felony. Wrong. State police power extends only to immediate threats to public safety, health and welfare, etc. Misciting Michigan v. Duke, or I mean, you state the title of the case, but we don't have a case number. So, yeah. The police power of the state must be exercised in subordination to the provisions of the U.S. Constitution, according to Buchanan v. Wanley from the Supreme Court. We don't know what year. Neither of these say anything about the use of emergency vehicle lights and sirens. And if it were a felony, provide the statute that makes it a felony. You can't. Does that mean it's not a felony? Probably. Defendant Dan emergency lights on his police vehicle and forced plaintiff off the road. Does that mean he did a pit maneuver? When I think forced someone off the road, I'm thinking pit maneuver. But I'm guessing He turned on his lights and had her pull over. At about this time, plaintiff turns on her cell phone and begins recording the events. Defendant Hansen approached the passenger side of plaintiff's automobile. Defendant Hansen is presumed to be armed with deadly weapons. It would be in poor taste for me to say her son found that out firsthand. So I won't say that. I won't say that, even if it is true. Although I'm working under the assumption that it was not Dane Hansen involved in Wednesday's shooting. There was no emergency, and defendant Dane Hansen stated his reason for stopping plaintiff was for expired registration. Hansen unlawfully detained and falsely arrested plaintiff without justification or probable cause. I wonder if she had the same fictitious license plate her son had. There was no charging instrument upon which defendant acted. There was no probable cause and no evidence upon which the defendant acted. There was no affidavit of probable cause upon which the defendant acted. Defendants wrongfully claim to have the right to enforce traffic codes in the face of plaintiff's constitutional rights. Defendant Hansen then demanded plaintiff's driver's license and insurance information. Plaintiff informed defendant she was not operating under a license and that she was traveling in private and not operating in commerce. I really need to get this body camera video. I need it. Defendant then asked, "Do you have your insurance information?" Plaintiff replied, "I'm not going to answer that." Defendant then said, "What about registration?" Plaintiff replied, "I'm not going to answer that." Plaintiff had her liberty to move about unlawfully restrained by defendant, despite the defendant's knowledge there was no probable cause for doing so. Defendant Hansen then asked for other documents which plaintiff had in her hand, which included plaintiff's passport and a copy of the Constitution for the United States. I'm guessing it wasn't a United States passport issued by the Department of State. Plaintiff provided these documents. Plaintiff then asked the officer for a level 2 officer to scan the passport and informed the officer she had a right to travel in her private property. Even assuming it's a US passport, and I don't know this, but I highly doubt that police officers have the ability to scan passports. Because why would they? Unless they're conducting an immigration checkpoint, they'd have no reason to scan passports. Defendant returned to his police vehicle, and after some time, another officer arrived on the scene. The second officer, Lieutenant Eric Johnson, who we heard from in the article I read at the beginning, is now Captain Eric Johnson, I presume. The second officer, Lieutenant Eric Johnson, upon exiting his vehicle, put on his bulletproof vest and then conversed with the other officer behind my automobile. Defendant Johnson is presumed to be armed with deadly weapons. Defendant Hansen returned to my automobile and asked for my date of birth. Plaintiff replied, "I'm not going to answer that." At this time, Defendant Hansen returned to his vehicle. After some time passed, Hansen returned to plaintiff's automobile and stated, As I said, the reason I stopped you was for the expired registration from September last year. Plaintiff then questioned, what was your probable cause for stopping me? Defendant Hansen replied, for the expired registration. Plaintiff replied, that's not probable cause. People versus Nothouse from Colorado, so a Colorado state statute has nothing to do with Utah traffic law. No state government entity has the power to allow or deny passage on the highways, byways, nor waterways. And then an ellipses, transporting his vehicles and personal property for either recreation or business. Another ellipses. Travel is not a privilege requiring licensing, vehicle registrations, or forced insurances. We don't know the date of that case. But once again, it's a Colorado case. So it has no impact on whether or not Utah can require registration and licenses. But I'm not going to look it up right now because this is already going to be long enough. But I can guarantee that there's a lot of context missing in these ellipses. Probably the contents of those ellipses will disprove the claim that Allen is making. Defendant Hansen then replied, okay, and continued speaking, stating, I stopped you for expired registration and driving without a license. Plaintiff then informed defendant he should know it's not probable cause and that if he had been properly trained, you should know that. Defendant continued, as I said before, it was for expired registration and driving without a license. Plaintiff handed the officer information about 18 USC 241 and 242 and information about right to travel and told him to read it. And 18 USC 241 and 242 are federal criminal statutes for deprivation of rights under color of law. Sovereign citizens love to shout about 241 and 242, even though it would take federal prosecutors to bring a case for deprivation of rights under color of law. It doesn't happen. It just doesn't, at least not for this. But sovereign citizens wave it about as if it's some sort of private cause of action. It's not. Defendant Hansen ignored the information he was requested, 18 USC 241 and 242, and a right to travel document, to read, then pulled a slip of paper off of his clipboard, presumed to be a citation. Plaintiff then stated, you are violating my rights under color of law, Title 18 USC 241 and 241. You are in violation of my rights. I'm hoping that that right to travel document is included as an exhibit at the bottom here, because that one could be fun. In fact, which one was it? I have too many things open. Oop, that's the wrong one. That one. Take a peek at the docket. It just lists the exhibit numbers. Poop. Oh well, we'll carry on. Defendant Hansen ignored plaintiff and then threw the paper citation through plaintiff's window, stating plaintiff was to call the court between 5 to 14 business days and walked away. Defendant Hansen did not ask plaintiff to sign the citation. Defendant issued plaintiff a citation for expired registration. Utah Code 41 1A 1303, and Utah Code 53 3 217 1A. No driver's license in possession, both infractions. It's almost like signing isn't it, signing it is not a contract. It just is it's a promise to appear. Cops realize sovereign citizens aren't going to sign it anyway, so why fight it? Of course, he could have arrested her, taken her to jail, and then issued the citations, but he went easy on her. Defendants Hansen and Johnson continued to both stand right at plaintiff's bumper of her automobile. Defendant Johnson moments later approached plaintiff's window and asked if I had questions. Plaintiff asked, "Am I being detained?" To which defendant Johnson stated, "You are free to go." Plaintiff also asked if the defendants had scanned her passport, to which defendant Johnson stated, "Why would I do that?" And then he walked away. Defendant Wayne Hansen, acting as chief of police for Farmington City, has either failed to train the other defendant officer properly or failed to supervise, leading to their violations of rights. Plaintiff is not a member of Farmington City, nor Farmington City Police, nor is plaintiff employed by anyone within this organization, and is under no obligation or duty to follow codes or statutes as a private state citizen. Right there, private state citizen. I'm guessing, although it doesn't say state national, I'm guessing if she's not directly a follower of Anna von Reitz, I'm guessing she's a follower of an offshoot of Anna von Reitz. Defendants, by their own admission, do not possess proper authorization to enforce traffic codes under the Department of Transportation. See Exhibit 1, Grandma Request Response. They're not enforcing traffic codes under the Department of Transportation. They're enforcing state traffic codes. State codes under the state of Utah, not under the Department of Transportation. Defendants, by and through their own admissions, state they have no contracts held, no obligations, nor any authority to violate plaintiff's rights. See Exhibit 2, Grandma Request Response. A few hours later, plaintiff went to the Farmington City Police Department with a witness, Chase Allen, that's her deceased son, and hand-delivered the rescissioned citation. The clerk, seemingly unaware, stated she would get an officer to handle it. It is a fact that a rescission to this citation was also sent via registered mail with the registered mail number, along with an affidavit of status and affidavit of truth and fact to each defendant. Affidavit and proof of delivery documents attached as Exhibit 3. So I was right. It wasn't done before the ticket, but it seems it is. I'm not part of your society. You have no authority over me. Affidavit of truth. Defendant, Lieutenant Eric Johnson, came out to the lobby and asked how he could help plaintiff. Plaintiff stated she was there to rescission the citation. Defendant Johnson then proceeded to crumple the citation into a ball and started to throw it in the trash can nearby and then refrained. Plaintiff then tried to show him on her passport where he is directed by the Secretary of State to allow citizens national of the United States named herein to pass without delay or hindrance, and in case of need, to give all lawful aid and protection. So I'm guessing that might actually be a US passport. Of course, some of the fictitious passports have that same language, but that doesn't give them the right to drive. Like, if you're from England, your passport will say His Majesty the King, assuming you've had a new passport in the last 6 months, otherwise it'll say Her Majesty the Queen, but, you know, uh, requests that you allow, the citizens of the United Kingdom to pass without delay or hindrance, and to give, it'll give this same language. That's for them to pass through immigration. It You'd still need a driver's license to drive in the US. I need to renew my passport, but my passport with this language doesn't give me the right to drive in the UK. My Utah state valid driver's license gives me limited, uh, you know, authority to drive in the UK, but it's not my passport. It's my valid driver's license, government issued driver's license. If I'm in the UK unless the law has changed since I lived in the UK, if I live in the UK for under a year, I can drive on an American driver's license. If it's for over a year, I have to get a British driver's license. Defendant Johnson then stated, "I don't have jurisdiction over a passport." That's true. He then insisted the citation/summons would not go away, and that if I didn't show up to court, plaintiff would have a warrant issued for her arrest. Defendant Johnson stated that the moment plaintiff enters the public roadway, that plaintiff is subject to the codes and statutes of the state of Utah, and that plaintiff must abide by these or be penalized. Defendant Johnson stated that plaintiff must register her vehicle in order to use the public roadways. Plaintiff explained to Defendant Johnson that her car was a private automobile and the public roadways are open to all to use freely to travel. Defendant Johnson then stated that if plaintiff didn't register her vehicle, it would be impounded. The witness then stated, "That's a threat," to which Defendant Johnson replied, "No, it's a promise. It's a promise." Defendant Johnson made a direct threat to plaintiff when he stated, "Your car is going to be impounded and we're going to take it away from you." Defendant Johnson made a direct threat to me when he stated, "Not if, we will impound your vehicle." Excuse me. Defendant Johnson was informed that such comments are a declaration of war against plaintiff. Plaintiff notified Defendant Johnson that she had come into department to resolve this matter peaceably. Plaintiff indicated to Defendant Johnson that the codes and statutes are for him to follow. Defendant Johnson was asked if he had sworn an oath to the Constitution, to which he replied he had sworn an oath to the Constitution and to the Utah Constitution. It is a fact that on April 7th, 2022, plaintiff sent by registered mail a notarized original of the same document to the Davis County Justice Court with a motion to dismiss for lack of jurisdiction. Proof of delivery of document is attached in Exhibit 3. It is a fact that upon calling the court on the confirmed receipt of plaintiff's documents and indicated the cause was frozen. Okay, I don't know what she means by frozen. It is a fact that plaintiff then received a notice of pretrial conference dated May 2nd, 2022, document attached as Exhibit 4. It is a fact that the plaintiff has never received service of process for any claim. But hang on, hang on. No service of process for any claim. We're on page 10. Right here on page 7. Defendant ignored plaintiff and then threw the paper citation through plaintiff's window, stating plaintiff was to call the court between 5 to 14 business days and walked away. There is your service of process. The citation is your service. And we'll go back to page 10. It is a fact that a court may not summon a plaintiff for anything other than a hearing or a trial. Okay, a pretrial conference is a hearing. It is a fact that the court did not respond to the plaintiff's first motion to dismiss. Is that because it wasn't properly served? Is it because you just sent it to the court, not to the prosecutors? Is it because it wasn't timely? Is it possible the court just denied your motion to dismiss? They don't have to issue a written reason. They can just say denied. It is a fact that there is no real party in interest. It is a fact there is no delicious corpse. I'm not going to do it. I'm not going to do it. I'm not going to say there was corpus delicti on Wednesday. Not going to do it. Nope. Okay. It is a fact that the Davis County Justice Court Judge John Carl Yinchowski and prosecutor David Cole held said status conference. Was Yinchowski issued a continuance. It is a fact that the certified copy of the court record indicates perjury on the record that alleged defendant refused to sign. Plaintiff was never asked to sign anything. It is a fact that plaintiff did submit a second motion to dismiss on June 8th, 2022, challenging subject matter jurisdiction and in personam jurisdiction. See Exhibit 5. It is a fact that Utah improperly cited, but I assume UCRP is Utah Rule of Criminal Procedure 12H, whenever it appears by suggestion of the parties or otherwise that the court lacks jurisdiction of the subject matter, the court shall dismiss the action. It is a fact that the prosecutor did not respond or object to plaintiff's motion to dismiss. It is a fact that the court did issue an order denying plaintiff's motion to dismiss on its own accord. Jurisdiction has not been proven. See Exhibit 6. So, funny story. In criminal courts, judges typically do deny the motion to dismiss on their own before a prosecutor responds. It's happened to me, not me as a defendant, me as a defense attorney. I've submitted motions to dismiss, not frivolous motions to dismiss like this, not not lawsuit motions. I've I had a uh, domestic violence case that we were going on 2 months, I think, and I'd been I'd had to ask for several continuances because the prosecution was not getting me discovery. They just would not. Finally, I'm in there for the next hearing. I'm like, look, judge, dipshit over here's not giving me discovery. Dismiss. Judge says, have you filed a written motion? I'm not gonna accept oral motions to dismiss. Turns to prosecutor. Most prosecutors I've dealt with have been very friendly, very, very easy to work with. This guy was an asshole. Total dick. He says, how long will it take you to get discovery over to Joe? I can get it by such and such date. Judge says, all right. If it's not in by then, file a written motion. Funny enough, it doesn't come. I file a written motion. Denied. It's almost like judges want decisions on the merits. Ugh. It is a fact that the plaintiff requested findings of fact and conclusions of law from Judge John Carl Inchesti. See Exhibit 7. It is a fact that Judge John Carl Inchesti did refuse to provide findings of fact and conclusions of law because he doesn't have to. It is a fact that the clerk, Jennifer Nicholas, did communicate John Carlian Chasty's refusal to provide findings of fact and conclusions of law via phone. Clerk indicated defendant in Chasty would only discuss at a pretrial conference. Plaintiff requested the response in writing. Clerk refused and said she would only put it in an email. It is a fact that clerk Jennifer Nicholas then made the presumption that plaintiff was recording the call, then stated it's against the law to record this call. I'm hanging up now. Clerk did disconnect the call with plaintiff. I believe Utah is a two-party consent state, and it's a fair assumption on the part of clerk Jennifer Nicholas. Always assume that sovereign citizens are recording. Just assume. They think laws don't apply to them. Assume they're recording in court. Assume they're recording on the telephone. Assume they're recording on the side of the road. Assume they're recording themselves on the toilet. I mean, it is a fact that the court is showing clear bias and prejudice toward the defendant or toward the plaintiff. It is a fact that plaintiff filed a motion to reconsider on August 4th, 2022, and has received no response. See Exhibit 8. It is a fact that pursuant to Utah, I'm assuming once again this is Utah Rule of Criminal Procedure, even though it's still cited wrong, incorrectly, but it's cited in a different fashion than the one above. Although looking back at it, Well, yeah, it's gotta be criminal procedure 'cause unless it's a typo here, because UCRP 1282, because presumably it would be 12B, because off the top of my head, the Utah Rules of Criminal Procedure fairly, or civil procedure, fairly, faithfully follow the numbering of Utah rule or the federal rules of civil procedure. But off the top of my head, I think it's 12B1 is motion to dismiss for lack of jurisdiction. But back to the probable Utah Rules of Criminal Procedure, Rule 25B4, mandatory dismissal. The court shall dismiss the information or indictment when the court is without jurisdiction. It is a fact that on August 24th, 2022, plaintiff did attend a pretrial conference, as other attempts to resolve this matter to date had been unsuccessful. It is a fact that plaintiff appeared specially and at arm's length to the court to challenge jurisdiction. It is a fact that Judge John Carl Inchausti then stated, so she does she doesn't state it beforehand, but this is where we get, I'm assuming this is her now deceased son that this next section is pertaining to. It is a fact that the judge then stated, "Sir, you need to step back behind the bar to my lawful assistance of counsel." Sovereign citizens believe you don't need an attorney, you need assistance of counsel, which can be any old schmuck. Look up what's his name? Rick. Oh, what's his name? My brain's trying to say Rick Allen, but that's the drummer for Def Leppard. Rick Martin. Rick Martin. He's the white-haired ponytail guy that there's a couple videos of him pontificating outside his SUV, but also he's the one that in the Michigan court got jailed for contempt, and the judge said to the defendant, "This isn't pizza," or I think she said Pizza Hut, but it would have been Burger King. "This isn't Burger King. You can't have it your way." This, so that was her assistance of counsel. Or the dude in Idaho, oh, what's his name? Kirk Pendergrass. Artie's Corporate Fiction has a couple videos on him. They both think they can be assistants of counsel and have been varying degrees of reprimanded for it. So he said to her lawful assistants of counsel, "You need to step behind the bar." My counsel then stated she has assistance of counsel. Defendant Inchausti then stated, "You're not counsel unless you can show me a bar license." The, the judge then instructed the deputies to ask plaintiff's counsel to seat back in the galley. It's gallery, not galley. Plaintiff then spoke up and said, "He is fine where he is. I am entitled to lawful assistance of counsel." It is fact that the judge said, "Let's go off the record right now," to the clerk. Then to plaintiff's counsel, "Sir, I'm going to have you once chance to do what I am ordering you to do." Plaintiff then asked defendant judge, "Is this a court of record?" To which he said it was a court of record. It is a fact that the Justice Court is not a court of record pursuant to Utah Code 78A 1-101 2. All courts of record except the Justice Courts, which are courts not of record. I believe that actually is the case. Not that it matters, but so in Utah justice courts or municipal courts, most of them for criminal cases, they try infractions, class C and class B misdemeanors. Most do not have jurisdiction over class A misdemeanors or any felonies. Um, the only exception I know to that is West Valley City, which is the second largest city in Utah by population, suburb, as the name would imply, in the west part of the valley, west of Salt Lake City. Um, they have jurisdiction over infractions and all misdemeanors. But in municipal courts, justice courts, if you're found guilty, you have a right to appeal to a district court. Here in Utah, district courts are the courts of general jurisdiction. So, like in lots of states, you'd have district courts are the equivalent of our municipal courts, and then circuit courts would be the equivalent of our district courts. Because, why would states have uniform naming conventions for the courts? Um, and and you can appeal. It's a trial de novo, meaning it's not your standard appeal. You can have a brand new trial in front of the district court judge. So my boss at the one law firm I worked for, uh, as an aside, so in these municipal courts, you don't get a preliminary hearing, a probable cause hearing. So whereas you do in district courts. So felonies and class A's, you you can request a probable cause hearing. Um, but you don't get that in municipal court. So what my old boss said is treat treat the trial in municipal court as the probable cause hearing. If you win, that's the equivalent of getting it chucked out at the probable cause hearing. If you lose, you appeal de novo to the district court, and you've already had a practice run in municipal court. You know better what to expect. You know, not that that is relevant to this, but it's just an aside. All right, finding my place. So it is a fact that the defendant judge then said, "Sir, I'm going to give you one chance to comply with what I'm ordering you to do, and then I'm going to ask the deputy to remove you." Assistance of counsel then asked, under Title 18, 1583, I don't know what 1583 is, but I'm not going to look it up. "Are you committing slavery and involuntary servitude?" Yikes. It is a fact that the judge then ordered the deputies to remove plaintiff's counsel from the room. Two deputies then drug him out of the courtroom against his will and against plaintiff's wishes, to which neither plaintiff or counsel consented. Counsel then cited Self v. Ray, which looks like it's probably federal court, but I'm not sure, which states codes and statutes are not law, they are corporate bylaws. No, they're not. Deputies then locked the doors, closing the to the public, with no other witnesses or public in the room or able to access the room. It is a fact that all courts are open to the public at all times. Upon plaintiff motion to dismiss for lack of jurisdiction, the judge denied the motion of his own accord, which he can do. It is a fact that jurisdiction has not been proven on the record, and the judge did refuse to provide findings of fact and conclusions of law. Plaintiff motioned the court to dismiss for lack of jurisdiction multiple times, all of which were denied by the defendant. It is a fact that the judge did not do what the law commands him to do. Jurisdiction is a threshold issue. This court may not proceed in any matter until jurisdiction has been proven. Jurisdiction has not been proven pursuant to USC 556D. And I assume Utah Rule of Criminal Procedure, once again, Rule 25B4, it must be dismissed. Jurisdiction, once challenged, is to be proven not by the court, but by the party attempting to assert jurisdiction. The burden of proof of jurisdiction lies with the asserter. The court is only to rule on the sufficiency of the proof tendered. See McNutt v. General Motors Acceptance Corp. From the Supreme Court. The origins of this doctrine of law may be found in Maxfield v. Levy from the Supreme Court in 1797. So, funny enough, you've got to have jurisdiction both in civil court, as in McNutt v. General Motors, but also in criminal court. The thing is, as all of you who follow sovereign citizen nonsense are sure to know, the ticket says you were pulled over in Farmington within the jurisdictional limits of Farmington. Therefore, the Davis County Justice Court and the Farmington City prosecutors, blah, 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 that's the rebuttable presumption of jurisdiction. If you want to challenge jurisdiction, you've got the rebuttable presumption, but you, as the defendant, have to bring the rebuttal. You've got to say, they don't have jurisdiction because. And then the county, the prosecutor, says, well, actually, we do have jurisdiction because of this. And then the judge says, all right, this is my ruling. But to just say, you don't have jurisdiction, you've got to prove jurisdiction, that's not how it works. It is a fact that the defendant judge did refuse to recuse himself for prejudice and bias upon plaintiff's motions. It is a fact that the plaintiff did state that on or for the record that all of my affidavits are stated in full herein. It is a fact that the defendant Rawlings, acting in his role as prosecutor, did admit that there was no affidavit of probable cause, charging instrument, and no information on the record. It is a fact that, pursuant to, presumably, once again, Utah Rule of Criminal Procedure, Rule 7B, C, the magistrate must dismiss the information and discharge the defendant. It is a fact that the defendant judge and defendant Rawlings, did grant defendant Rawlings more time to submit an information on the record, even though there has been no ratification or commencement, and defendant Stainham Hansen, Eric Johnson, and Wayne Hansen in Farmington City is stopped from pursuing this cause as they have defaulted, and the affidavit has gone unrebutted, mailed via registered mail, received on April 12th, 2022, and acquiesced and are in default. Talk about corporate fiction. If the defendant judge did set a trial date without any ratification and commencement and no proof of jurisdiction. It is a fact that the judge did stereotype and or discriminate and state, I've dealt with people like you before. Yikes. First cause of action. Declaratory judgment and federal question. Plaintiff adopts and realleges paragraphs 1 through 106 of this complaint as though fully stated herein. The defendants did enforce a code, in quotation marks, under the color of law that is in conflict with the constitutional right to be secure in your persons, papers, and effects, to enforce upon and extinguish the rights of the plaintiff, to the bitter end of forcing plaintiff into involuntary servitude. So, unfortunate fact here. I mean, they're not forcing her into involuntary servitude, but the 13th Amendment abolished slavery except as punishment for crimes. I believe Utah, just in the last few years, modified its constitution to actually do away with such provisions. So now in Utah, all slavery is illegal, but at the federal level, and remember, she's suing under federal question, involuntary servitude's not illegal as punishment for a crime. That's unfortunate. It needs to be changed, but yeah. The code enforced by the defendants is in conflict with the Utah Constitution, Article 1, Section 14. Said codes were also misconstrued to include private travelers. The code enacted by the state of Utah does not appear on its face to be in compliance with 18 U.S.C. 31 and 49 U.S.C. 31301. The defendant police officers on or about April 7th, 2022, did trespass upon plaintiff's rights without due process of law, without probable cause, and without proper warrant to deprive the plaintiff of her constitutionally secured rights, and in violation of Title 18 USC 21 or 241 and 242, as well as Utah Code 76-8-201. And then citing Murdoch v. Pennsylvania, no state may convert a secured liberty into a privilege and issue a license and fee for it. Murdoch v. Pennsylvania is one of the most cited, most miscited sovereign citizen cases. 18 U.S. Code 245 B2E, federally protected activities. E, traveling in or using any facility of interstate commerce or using any vehicle, terminal, or facility of any common carrier by motor, rail, water, or air. And that is wholly irrelevant to the question at hand. To make a civil infraction out of the use of and the right to access public roadways and travel in private is an arbitrary and capricious abuse of discretion without due process of law. Such conduct is a direct assault on the plaintiff's right without consideration and disregard of the facts. On or about April 7th, 2022, the defendants did deny rights clearly belonging to plaintiff under the guise of state laws and federal laws, among others, without just compensation. First federal question: when in the course of the business affairs of defendants coming against the rights belonging to plaintiff, are the defendants subject to uphold plaintiff's constitutionally guaranteed rights? Question mark. Plaintiff contends yes, but defendants did not. Therefore, the plaintiff is entitled to injunctive relief against defendants to enjoin the defendants from enforcing unconstitutional codes and statutes against plaintiff. Second federal question: must the defendants comply with federal law, Utah law, the United States Constitution, and the Constitution of the state of Utah? Question mark. The plaintiff contends yes, but defendants did not. Therefore, the plaintiff is entitled to injunctive relief against defendants to enjoin the defendants from enforcing unconstitutional, unlawful actions against plaintiff. Third federal question: must laws enacted by the state of Utah and adopted by the defendants be in compliance with Article 1, Section 3 of the Utah Constitution and the Fourth Amendment to the Constitution for the United States of America? Question mark. Plaintiff contends yes, but said laws are contrary to the Utah Constitution. Fourth federal question: must police officers enforcing traffic codes be authorized under federal law and the Department of Transport and be properly trained before enforcing transportation codes? Question mark. The plaintiff contends yes, but defendants did not. Wherefore, plaintiff requests judgment against defendants. Second cause of action: 42 U.S. Code 1983, false arrest. Plaintiff preceding paragraphs. The defendants unlawfully detained and falsely arrested plaintiff without legal justification or probable cause. Defendants knew that plaintiff had not committed any crimes and still continued to effectuate the arrest, detention, and prosecution of plaintiff for the charge. The misconduct described in this count was undertaken with malice, willfulness, and recklessness, or reckless indifference to the rights of plaintiff. The misconduct described in this count was objectively unreasonable and was undertaken intentionally with willful indifference to plaintiff's constitutional rights, specifically the First, Fourth, Sixth, Ninth, and 14th Amendments and Section 9 and 10 of the Constitution for the United States, and hence 42 U.S. Code 1983. I noticed she missed the 10th Amendment in that laundry list. As a result of the unjustified violation of plaintiff's rights by the defendants, plaintiff has suffered injury of anxiety, emotional distress, loss of enjoyment of life, time lost to address this matter, and economic damages. You could have paid the $100 ticket and be done with it, Karen. Third cause of action: 42 U.S.C. 1983, unreasonable search and seizure. Plaintiff adopts and realleges, blah, blah, blah. As a direct and proximate result of the defendant's actions under color of law, plaintiff was deprived of plaintiff's constitutionally protected rights to due process of law. As a direct or proximate result of the defendant's actions, plaintiff was deprived of her to equal protection of law, to be free from unreasonable search and seizure without warrant, and to privacy. As a result of the unjustified violation of plaintiff's rights by the defendants, plaintiff has suffered injury, anxiety, emotional distress, loss of enjoyment of life, time lost to address this matter, and economic damages. Fourth cause of action: 42 U.S. Code 1983, conspiracy to commit constitutional violations. Plaintiff adopts and realleges, blah, blah, blah. As discussed in greater detail above, the defendants conspired with each other to cause damage to plaintiff by knowingly participating in violation of plaintiff's constitutionally protected rights, by making threats of kidnapping and theft of private property, by destroying and concealing documents with the intent to cause further injury to plaintiff, 18 U.S. Code 2071, concealment, removal, or mutilation generally. The aforementioned actions of the defendant officers were the direct and proximate cause of the violations of the United States Constitution discussed above. Plaintiff has suffered injury, anxiety, emotional distress, loss of enjoyment of life, time lost to address this matter, and economic damages. Defendants did violate plaintiff's rights under Amendment 4 to the Constitution to be secure in the persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause to be supported by oath or affirmation. Defendant did violate Amendment 6 to the Constitution, and to be informed of the nature and cause of the accusations to be confronted with the witnesses against him. Defendant did violate Amendment 7 to the Constitution. In suits at common law where the controversy shall exceed $20, the right to trial by jury shall be preserved. This isn't a suit at common law. And the Seventh Amendment right to jury in civil suits hasn't been ascribed to the states by the 14th Amendment. Defendant did violate Amendment 5 to the Constitution, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. You were not called upon to be a witness against yourself. And the court process, the justice court where you had hearings, that's your due process of law. Sovereign citizens don't seem to understand you're entitled to due process of law, not your process of law. Due process, notice, and opportunity to respond. You were given notice, your citation. Evidence of the notice is you showed up to court. The opportunity to respond, court. Due process. Defendants did violate Section 9 of the Constitution. Section 9. Which article? Which article? I mean, no bill of attainder, ex post facto law. What bill of attainder? What bill of attainder? So a bill of attainder is something that the founders who wrote the Constitution found absolutely abhorrent because King George passed bills of attainder. And bills of attainder are acts of Parliament or the Crown saying this person has done something illegal. It's criminal statutes aimed at a person for something they have done. And saying this person is guilty of this. And yes, that is unconstitutional. As are ex post facto laws, which are laws passed after you've done something and then you're charged with it. So neither of those have happened here. For an example of an ex post facto law, though, in a case I've covered but haven't actually updated this. So look to the Alec Baldwin case. The firearm enhancement was dropped recently. Why was it dropped? Because that portion of the law had changed between the time of the Rust shooting and Alec Baldwin being charged. So the district attorney charged him under the law as it was written when she charged him. She realized, oops, that's an ex post facto law. So she dropped it. That's the law working as it's supposed to. I mean, it shouldn't, you should know anyways and not charge people with ex post facto laws. But the DA dropped it because she realized her mistake. So, and Section 10, no state shall pass any bill of attainder or ex post facto laws when they issued a citation against plaintiff. That's not a bill of attainder or an ex post facto law. That's the commencement of the suit against you. Defendant did violate Utah Constitution, Article 1, Section 14. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, particularly describing the place to be searched and the person or thing to be seized. Funny how the Utah state constitution very closely mirrors the federal constitution, at least in like Fourth Amendment is closely mirrored by Article 1, Section 14, which was written long after the Fourth Amendment. So it's an article of the Constitution, of the state constitution, instead of an amendment. The court erred in application of procedure and law as the defendants failed to state a cause of action, provide probable cause, assigned information, sworn under penalty of perjury, signed affidavit, or any other proper evidence. Hence, pursuant to Federal Rule of Civil Procedure 12b-6, it must be dismissed. So she actually properly cited Federal Rule of Civil Procedure 12b-6, but she misapplied it because why, just why would the federal rules of civil procedure apply in state criminal court? They wouldn't. Fifth cause of action, 18 U.S. Code 241, 242, conspiracy against rights. Well, this cause of action, 12b-6, failure to state a cause upon which relief can be granted. Why? Because, like I said earlier, these are criminal statutes. They're not a private cause of action. Unless the U.S. attorney thinks, yeah, Diane Allen's rights were violated, the U.S. attorney's not going to charge her, so these don't apply. But we'll look at it just the same. Plaintiff adopts and realleges, blah, blah, blah. Defendants knowingly participated in violation of plaintiff's constitutionally protected rights. Defendants did arrest plaintiff without probable cause, without a proper warrant, and without reasonable articulable suspicion of a crime and no delicious corpse. Defendants did make a threat of kidnapping. Defendants did make threats of theft of private property. Defendants did destroy and concealing documents with the intent to cause further injury to plaintiff. Defendants did perjure themselves on the record. Defendants did violate their oaths to the Constitution for the United States and the Utah Constitution. Defendant Eric Johnson did either willfully conceal his signed oath of office or has not sworn and subscribed an oath of office. See Exhibit 9. The aforementioned actions of the defendant officers were the direct and proximate cause of the violations of the United States Constitution discussed above. Plaintiff has suffered injury, anxiety, emotional distress, loss of enjoyment of life, time lost to address this matter, and economic damages. Sixth cause of action, prejudice and bias. Plaintiff adopts and realleges paragraphs 1, blah, blah, blah. This court may not proceed in any matter until jurisdiction has been proven. Jurisdiction has not been proven. Pursuant to probably the Utah Rules of Criminal Procedure, Rule 25B4, it must be dismissed. Jurisdiction, once challenged, is to be proven not by the court, but by the party attempting to assert jurisdiction. The burden of proof of jurisdiction lies with the asserter. The court is only to rule on the sufficiency of the proof tendered. See McNutt v. General Motors, blah, blah. We saw that already. Plaintiff did not receive service of process of any alleged matter. There has never been proper service of process. The essential elements of due process are notice and an opportunity to defend, citing Simon v. Kraft from the Supreme Court. Without lawful notice, there is no personal jurisdiction, and all proceedings prior to filing of a proper trial document in compliance with the elements of jurisdiction is void. Once again, the citation was service. You even admit it. They put it through the window of your car. Burden of proof. The defendant has the burden of production to come forward with facts demonstrating a prima facie case. Per 5 USC 556D, the burden of proof rests with the prosecutor in this traffic citation case, or cause, like all others, to prove all elements of the charge. They have provided no proof and have not objected to the motion to dismiss. That's because the judge, on his own, sua sponte, denied your motion to dismiss. There exists no probable cause, no affidavit of probable cause, and no proper information filed with the court. Pursuant to, presumably, once again, Utah Rules of Criminal Procedure, Rule 7B, the magistrate must dismiss the information and discharge the defendant. All information provided to date from Farmington City and by and through the prosecutor is hearsay. And it's not being used to prove anything yet. That's what the trial is for. And the trial is where hearsay is not allowed. No direct evidence of any crime has been presented. Informations are not due process of law. There exists no accusation that has been made under penalty of perjury, nor has a first-hand witness come forward. The officers, they're first-hand witnesses. Information acquired from software and or computer databases is not based on facts or evidence and is third-party information and hearsay and does not comply with the Federal Rules of Evidence 602 need for personal knowledge. Well, funny enough, once again, the Federal Rules of Evidence do not apply in state court. Utah Rules of Evidence apply. Now, the information acquired from a software computer database, such as the vehicle registration database, it's a document prepared in the ordinary course of business or an official document. Those, by the rules of evidence, are not hearsay, or they're exceptions from hearsay. I can't, there are some things that are explicitly not hearsay, and there are some things that are hearsay but are allowed just the same. This would be one of those. Seventh cause of action, 42 U.S. Code 1983, failure to intervene. Plaintiff adopts blah, blah, blah. As described more fully above, one or more of the defendants had a reasonable opportunity to prevent the violations of plaintiff's constitutional rights as set forth above. As a result of the defendant's failure to intervene, plaintiff suffered loss of liberty as well as anxiety, emotional distress. There's a missing and there. I always get hung up reading aloud when there's a grammatical error. It makes my brain skip. The defendant's actions were undertaken intentionally with malice and reckless indifference to plaintiff's rights. The misconduct described in this count was undertaken by the defendants within their scope of their employment and under color of law. A cause of action 42 USC 93 malicious prosecution. Plaintiff adopts and realleges blah blah blah. As described more fully above, the defendants commenced, caused to be commenced, and or continued a criminal proceeding against plaintiff for which defendants knew there was no probable cause and no charging instrument and no crime. Traffic infractions are not crimes. Traffic infractions are not crime. Emphasis added. Being subject to only local regulation, i.e., safety, caution, traffic lights, speed limits, etc., travel is not a privilege requiring licensing, vehicle registration, or forced insurances. Chicago Coach Company v. City of Chicago. Another favorite case of sovereign citizens, which, if memory serves, is also a state case out of the state of Illinois. So it doesn't apply here. This is misconstrued because it does not grant you the right to drive without a license, but also this traffic infractions are not a crime in Illinois. In Illinois, the state of Utah gets to decide whether traffic infractions are criminal or civil. Fun fact, in Utah, they're not either criminal or civil. They're infractions. They're pseudo criminal. The defendant's actions were undertaken intentionally with malice and reckless indifference to the rights of others, specifically the plaintiffs. As a result of the defendant's malicious prosecution, plaintiff has suffered injury, anxiety, emotional distress, loss of enjoyment of life, time lost to address this matter, and economic damages. Said defendants continue to prosecute plaintiff on false evidence or hearsay. So that gives you an idea right here. As of the time of her filing this complaint, the traffic case was ongoing. You're never going to win a civil rights case if you haven't already beaten the traffic case. And even then, just because you're found not guilty doesn't mean your rights were violated. It means usually that the state believed you had committed a crime, but they weren't able to prove it beyond reasonable doubt. It takes more than that for your rights to have actually been violated. Said defendants continue to prosecute plaintiff with no real party in interest. Said defendants continue to prosecute plaintiff with no delicious corpse. There is no injured party. Delicious corpse. For a crime to exist, there must be an injured party. Delicious corpse. There can be no sanction or penalty imposed on one because of this constitutional protected right, citing Sheriff v. Cullen from this, federal court. Said defendants continue to administrate plaintiff and her property right. It is a fact that there is no contract that would obligate plaintiff to perform. Clearfield Trust Co. v. United States, from the Supreme Court. Hey, she actually gave us a year, 1942. Governments descend to the level of mere private corporations and take on characteristics of a mere private citizen, ellipses, where private corporate commercial paper, Federal Reserve notes, and securities checks is concerned, another ellipses, For purposes of suit, such corporations and individuals are regarded as entities separate from government. Once again, there's an awful lot of context missing in those ellipses. Ugh. StreamYard decided to freeze on me, so now I have to do the bane of my existence, video editing. Ugh. But jumping right back into it, we have the ninth cause of action: state law claim, armed assault. Plaintiff adopts and realleges, blah, blah, blah. At that time, plaintiff had a reasonable apprehension that she was in considerable danger and would be subjected to great bodily harm. Additionally, defendants were presumed to be armed with deadly weapons. Plaintiff had a reasonable belief that those deadly weapons would be used against her if she did not comply. The misconduct described in this count was undertaken with malice, willfulness, and reckless indifference to the rights of others, specifically the plaintiff. As described in the preceding paragraphs, the conduct of the defendants, acting under color of law and within the scope of their employment, was undertaken willfully and wantonly, proximately causing plaintiff's injuries. And once again, I'm I'm not going to make the joke that that cause of action was a foreshadowing of future events. I'm not going to do it. I just won't. 10th cause of action: simulation of legal process. Simulation of legal process. Okay, that one broke me. That one got me. Jesus Christ. Simulation of legal. Seriously. Okay, Joe, get it together. Get it together. The defendants issuing security. Oh, issu- issue. I don't know why I found this one so funny. Issuing securities against plaintiff when no contract exists and no crime or affidavit of probable cause is a simulation of legal process and abuse of process. Locking court doors during business hours and locking plaintiff inside is simulation of legal process intended to harass, injure, threaten, and defraud plaintiff. Per the Constitution for the United States and the Utah State Constitution, all courts are to be open to the public. Her assistance of counsel forfeited that right to be present. Defendants moving a fraudulent case against plaintiff for unjust enrichment of defendants without any appearance of due process or rule of law is a simulation of a legal process. Oh, I'd say you can't make this stuff up. Pussy has. Defendants proceeding in this fraudulent action with no jurisdiction is a simulation of a legal process and violation of plaintiff's right to due process and protections under the Constitution for the United States. 11th cause of action, state law claim, respondeat superior. This isn't a cause of action. It's respondeat superior is basically if I am an employee and I hit someone with my truck on the job, they sue me, but they also sue the employee or the employer, the superior. The They're responsible for my torts while I'm working for them. But that's not a cause of action. That's just it's how you get the other party jurisdiction over the other party. That's it's not a cause of action. Plaintiff adopts and realizes blah blah blah. Um In committing the acts alleged in the preceding paragraphs, the defendants were acting as members and agents of Farmington City Police, acting at all relevant times within the scope of their employment. Defendants Farmington City is liable as principal for all torts committed by its agents when acting as its agent. 12th cause of action, state law claim, indemnification. The Utah law provides that public entities are directed to pay any tort judgment for compensatory damages for which employees are liable within the scope of their employment activities. The defendants are employees of the Farmington City Police, Davis County Attorney's Office, and Davis County Justice Court, respectively, and who acted within the scope of their employment in committing misconduct described herein. Damages. Plaintiff adopts and realizes blah blah blah. Plaintiff suffered actual, compensatory, special, punitive, and treble damages. You've, I mean, you've got to give a statute. Treble damages is a statutory thing saying if you suffered this much in damages due to a violation of this law, you get triple that amount. You've got to say which statute gives you treble damages, like antitrust violations. Those are treble damages. As a result of the nature and consequences of her damages, plaintiff suffered mental anguish, emotional distress, loss of enjoyment of life, time lost to address this matter, and economic damages. Plaintiff seeks such recovery, together with all damages to which plaintiff may show to be justly entitled, which amounts are in excess of the minimal jurisdictional limits of this court. Defendants may be liable for additional damages that come to light during the discovery process or at trial. Interest. Plaintiff pleads entitlement to prejudgment interest at the rate allowed by law and no more than is allowed by law on any damages awarded by this court to them. What's the interest rate on nothing? Plaintiff further pleads that if plaintiff is not allowed such prejudgment interest, he will not be fully compensated. In addition, plaintiff pleads entitlement to post-judgment interest in the maximum amounts allowed by law and no more than is allowed by law until the judgment is paid. Request for emergency injunctive relief. Plaintiff seeks to enjoin the defendants from the following: conducting or participate in conference, hearings, or trial, or in issuing any orders related to or involving plaintiff, taking any action to kidnap plaintiff, taking any action to take property in use by plaintiff. Threat is imminent. Accordingly, plaintiff respectfully requests that the emergency temporary restraining order issue without notice. Irreparable harm. In addition, plaintiff has and will suffer continued defamation of character. Whoa, we've covered so many defamation cases. What what's required for defamation? It's got to be false. What's false here? It's got to be defamatory in nature. It's got to cause damage. It's got to be published. What, what's been published or disseminated or but apparently the plaintiff is likely to prevail on the merits of this petition and claim. Except you haven't we just read all the causes of action. There isn't one for defamation. So so how are you going to prevail on the merits of this petition and claim for defamation of character when you haven't even pled it as a cause of action? Wherefore, premises considered Diane Killian Allen requests. So she's premises? There's too many jokes to make about her being premises. Or oh, oh, okay. It's these premises considered Diane Allen requests. Okay. I thought she was calling herself a premises, and I was going to make jokes about people being entitled to enter said premises, but that would have been wrong. But that I think that was the wrong reading of the sentence. Yeah. She requests a temporary restraining order be issued without notice to the defendants, restraining defendants, their attorneys, trustees, agents, servants, representatives, assignees, substitutes, and employees, and the Davis County Justice Court and their attorneys, trustees, agents, servants, representatives, assignees, substitutes, and employees from conducting or participate in conference, hearings, or trial, or in issuing any orders related to or involving plaintiff, taking any action to kidnap plaintiff, taking any action to take property owned or in use by plaintiff. Uh, Defendants be cited to appear and show cause, and that on such hearing a preliminary injunction be issued, enjoining defendants, their attorneys, trustees, trustees, agents, servants, representatives, assignees, substitutes, and employees from conducting or participate in conference, hearings, or trial, or in issuing any orders related to or involving plaintiff, taking any action to kidnap plaintiff, taking any action to take property owned or in use by plaintiff, a permanent injunction to be ordered on final trial of this cause, enjoining defendants, their attorneys, trustees, substitute trustees, agents, servants, representatives, assignees, substitutes, and employees from conducting or participate in conference, hearings, or trial, or in issuing any orders related to or involving plaintiff, taking any action to kidnap plaintiff, taking any action to take property owned or in use by plaintiff, actual, compensatory, special, and exemplary damages. So basically, she's asking the federal court to say, now, state, you've been very, very naughty, and you can't ever arrest her again for anything. She is officially, by federal court decree, above the law. That's what she's asking for here. Along with statutory penalties, costs of court in bringing this suit, all further relief, general or specific at law or equity, together with such other and further relief as the court may deem reasonable and just under the circumstances. Wherefore, plaintiff Diane Killian Allen respectfully requests that this court enter judgment in her favor against the defendants, awarding compensatory damages and fees along with punitive damages against the defendants in their individual capacity, as well as any other relief this court deems just and proper. Trial by jury demand. Plaintiff Diane Killian Allen hereby demands a trial by jury pursuant to Federal Rule of Civil Procedure 38B, as well as pursuant to the Seventh Amendment to the United States Constitution on all issues so triable. Respectfully submitted this 9th day of September 2022 by Diane Killian Allen. Yikes. And then we have the affidavit in support of the petition and request for emergency injunctive relief. Is it going to be the same as the one we looked at the towards the beginning, talking about her motion for summary judgment? I, Diane Killian Allen, am the named plaintiff above, and state and swear before God, under penalty of perjury, under the laws of the United States, that the following is true and correct to the best of my knowledge. I am over the age of 18 and am competent to testify before this court. I am the plaintiff in the above entitled action and am familiar with the files, records, and pleadings in this matter. The facts set forth in this petition are true and correct to the best of my knowledge. Respectfully submitted this 9th day of September 2022 by Diane Killian Allen, and it's notarized. So that was a blank affidavit. That was nothing. Oh dear God. Seriously. Uh, I'm actually speechless. I, I'm Exhibit 1. This is the grandma request, validation of citations. Dear Ms. Allen, I write in response to your June 7th, 2022 grandma request, which Farmington City received on June 7th, 2022, for records relating to identifying you as a person, records identifying you as a dead entity or slave, records identifying you as an employee, records identifying you as a resident, records identifying you as required to register an automobile, records requiring that a 2014 BMW is required to be registered, records that you were operating the vehicle for hire, records related to Farmington having jurisdiction over you, records that you are the owner of the 2014 BMW, records that your 2014 BMW is a vehicle. Remember, she calls it her automobile. Records relating to enforcement actions involving you or your BMW. Records relied on to show the failure to register the vehicle was applicable to you or your BMW. Records regarding any contracts obligations by you to Farmington City. Records relating to Officers Hanson and Johnson and their legal standing to file a citation in the Davis County Justice Court. Records that show legal authority to issue summary offenses against you. Records that show you are a resident of the city of Farmington. Records evidencing ownership interests in your 2014 BMW. Records regarding the compensation of Officers Hanson and Johnson. Records of job descriptions for Officers Hanson and Johnson. And records related to bonds secured by Farmington City to cover damages in their official roles. After conducting a thorough search, Farmington City has identified documents responsive to your request. Those documents are provided. Any of your requests that did not have any responsive documents are noted below. Ah, yikes. I'm not going to read all 60 pages of nonsense, but I am going to read this one. If you recall, Exhibit 3 is the affidavit of status or affidavit of truth and rescission of status by Diane Allen for that she brought to the sheriff's office or the police station after she received her ticket. Affidavit of status. I, Diane, colon, Killian dash Allen. Quantum grammar, anyone? Is she a follower of Russell J. Gould or what's the other dude's name? The Either way, there's the quantum grammar nonsense that, although this doesn't seem to be full quantum grammar, just the name. I, Diane Killian Allen, a woman, am over the age of consent, am a creation of God Almighty, and a follower of God's laws first and foremost, and the laws of man when they are not in conflict. Leviticus 18:3 and 4. D- I mean, says she's a follower of God's laws first and foremost, and the laws of man's when they are not in conflict. So, does God have laws about vehicle registration? I kind of doubt it. But let's move on. Pursuant to Matthew 5:33 through 37 and James 5:12, let my yea be yea and my nay be nay, as supported by federal public law 97-280, 96-1211, where, as the Bible, the Word of God, has made a unique contribution in shaping the United States as a distinctive and blessed nation and people, and whereas biblical teachings, inspired concepts of civil government that are contained in our Declaration of Independence and a Constitution of the United States, and whereas the Bible is the rock on which our republic rests. I have personal knowledge of the matters stated herein, and hereby understanding both the spiritual and legal liabilities of thou shalt not bear false witness against thy neighbor. Being a woman of God, a living soul of flesh and blood, of sound mind. Press X to doubt. Intelligent and a member and of competent nature, the creditor, beneficiary, and holder in due course of the trust. I am a member and proud descendant of we the people, as creator and arbitrator of government. I am not one artificially created by government, such as citizen, person, resident, or taxpayer at all. That affiant is not a corporation created under the laws of the United States or any state, the District of Columbia, or any territory, commonwealth, or possession of the United States, or a foreign state or country, public or private. That affiant status is supported in the Declaration of the United States of America, July 4th, 1776, when, in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them. Uh, Decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, Governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive to these ends, it is the right of the people to alter or abolish it, and to institute new government, laying its foundation on such principles, and organizing its powers in such form as to them shall seem the most likely to affect their safety and happiness. That affiant status is in support of Title 8 USC 1101 A 21 and 23. The term national means personal owing permanent allegiance to a state. 23, the term naturalization means the conferring of nationality of a state upon a person after birth by any means whatsoever. That affiant is not an officer, agent, shareholder, franchisee, or fiduciary agent, resident, inhabitant, or domiciled in any corporation. That affiant is not a vessel documented under Chapter 121 of Title 46 USC, or a vessel numbered as provided in Chapter 123 of that title. That affiant is not an enemy of the United States or any corporation created under the laws of the United States or any state, the District of Columbia, or any territory, commonwealth, or possession of the United States or a foreign state or country, public or private. Any presumption that affiant is any of the above, or documentation implying any of the above, is not the act or intent of this affiant, and any such presumption or documentation is fraudulent, illusionary, false representation of a matter of fact, or a kind of artifice employed by one person to deceive another for self serving purposes. BS. Remember, she presented a passport. She presented a passport to the officers. So either she presented a false identity, a false instrument, uh, passport provided by Anna von Reitz or by Freedom from Government, the Santa Claus looking dude from uh, Nye County, Nevada, or one of the other false gurus, or she has a valid U.S. passport, which means she's a U.S. citizen. So either she's committed fraud or she's lying in this affidavit, which is a crime. That affiant is neither affiliated with or an enemy of any public or private corporation, domestic or foreign, but is a neutral body. That affiant's name and the location of are particularly unique to this affiant, although not affiliated with the corporate body politic near the same location, and it suffices as complete, necessary, and sufficient in identification and evidencing affiant's neutral standing, citing 15 USC 1681H. In these United States of America, the authority of any and all governments resides in the people of the land, for government is a fiction of the mind and can only be created by the people, affected by the people, overseen by the people, for the benefit of the people, and to secure the individual God given rights of the people. Of the people, not of the person. I reserve, claim all, and waive none of my God given, secured, and guaranteed rights pursuant to the Declaration of Independence, not a governing document, and the Constitution for the United States of America as ratified in 1791, with the Articles of the Amendments. Pursuant to the Constitution for the United States of America as ratified in 1791, with the Articles of Amendments, Article 6, Paragraph 2, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The 10th Amendment is in that Constitution. As a matter of their lawful compliance to the referenced Constitution, any of the people, while functioning in any public capacity in return for the trust of the people, are granted limited delegated authority by the people with specific duties delineated in accordance thereof, shall only do so pursuant to a lawfully designated, sworn, and subscribed oath of office, and any and all bonds required thereof. The only court authorized by the referenced Constitution to hear matters of the people is a court that conforms to the functions in accordance with Article 3, Section 2 of the referenced Constitution, in which all officers of the court abide by their sworn and subscribed oaths of office and support and defend the rights of the people and are heard only in trial by jury in accordance with all aspects of due process of law. Wrong. Wrong, wrong, wrong. Wrong. The only, I mean, yeah, Article 3, Section 2 establishes courts. It says, um, or this is from memory, so it's going to be wrong. But the gist of it is it says, we're establishing a Supreme Court and such inferior courts as Congress, either Congress or the Supreme Court, but I think it's Congress, shall create from time to time. Basically. But then that's the federal judiciary shall consist of a Supreme Court and such inferior courts as Congress shall deem from time to time. But then that's Article 3 courts. If I recall, magistrate courts and bankruptcy courts are not Article 3 courts. I'm going off of memory. But I'm pretty sure tax court. Um, but that's just the federal judiciary. State courts are created under the authority of the state constitutions. I'm guessing the next paragraph is going to say, and they only have admiralty or common law jurisdiction. At some point, I'm going to make a video on just that. Pursuant to the supreme law of the land and the God-given rights secured and guaranteed therein, this Constitution is established to ensure the dominion granted by God to all people on this land shall endure and ensure forever that the people on this land shall be free from any and all slavery, indenturement, tyranny, and oppression under the color of law, statute, code, policy, procedure, rule, regulation of any other type. Pursuant to this Constitution, I cannot be compelled, manipulated, extorted, tricked, threatened, placed under duress, or coerced, or so affected under the color of law by any natural person who, individually or in any capacity, as or under any artificial person, agency, entity, officer, or party, into waiving any of my rights, or to act in contradiction thereof, or to act in opposite of the moral conscience and dominion granted to me by God, nor can I be deprived of any of these rights, privileges, and immunities except by lawful process in accordance with the law without the natural and or artificial person in whatever capacity. Anyone using any process not in accordance with the Constitution, causing injury to me, thereby commits numerous crimes requiring lawful punishment therefrom. I set out on this ground, which I suppose to be self-evident, that the earth belongs in usufruct to the living, that the dead have neither powers nor rights over it. Thomas Jefferson in letter to James Madison, criticizing the new Constitution, September 6th, 1789. At some point in time, one recognizes the fraud. I, the woman, have awakened to the fact that it is I, the living woman, whose blood, sweat, and tears of her labor that has been fraudulently held as the surety and as the debtor, when in reality it is I that is truly the holder in due course and the actual creditor. That's the straw man nonsense. But alas, the government corporation deems that the man is lost at sea by his very state, while her employees, the government corporations, steal the fruits of his labor. Lost at sea. That's part of their maritime law nonsense. And the birth, because it's a birth certificate, because ships are birthed, and I know right from wrong. If there is any woe man damaged by any statements herein, if she or he will inform me by facts, I will sincerely make every effort to amend my ways. And they did by filing suit against you for traffic infractions. I hereby and herein reserve the right to amend and make amendments to this document as necessary in order that the truth may be ascertained and proceedings justly determined. If the parties given notice by means of this document have information that would controvert and overcome this affidavit, please inform me in written affidavit form within 10 days from receipt hereof, providing me with your counter affidavit, providing with particularity by stating all requisite actual evidentiary fact and all requisite actual law, and not merely the ultimate facts or conclusions of law, that this affidavit statement is substantially and materially false, sufficiently to change materially my status and factual declarations. Your silence stands as consent to and tacit approval of the factual declarations herein being established as fact as a matter of law. May the will of our Heavenly Father, through the power of and authority of the blood of His Son, be done on earth as it is in heaven. Like I said, they think that having a notarized affidavit gives it the power of law, and if you don't refute it, by gum, it's you're bound by it. But that's just cosplaying as humans. It's nonsense. Reserving all my natural, God given, unalienable rights, waiving none ever. Further, that I do solemnly attest that the foregoing facts contained herein are true, correct, and complete to the best of my knowledge and belief, under the penalty of perjury in accordance with the laws of the United States and the law of nations. For cause status. Per 28 U.S. Code 1746, unsworn declarations under penalty of perjury, if executed without the United States, I declare or certify, verify, or state under penalty of perjury under the laws of the United States of America that the foregoing is true and correct, executed on this 9th day of April, uh, in the year of our Lord 2022. Without prejudice and without recourse, I hereby place my autograph below by Diane Killian Allen, executor, with an, I'm assuming that's red ink fingerprint. And notice to agents is notice to principal. Notice to principal is notice to agents. This is the end of this affidavit. Now, I notice, and she noticed it too, but didn't realize it. This isn't an affidavit, even. This is a sworn declaration. She even put the law for federal courts about Well, unsworn declarations under penalty of perjury. It's not notarized. It's not an affidavit, or at least not a sworn affidavit. Even under her fiction, she gets it wrong. She thinks this so-called affidavit has the force of law, which it wouldn't anyways, but it's not even an affidavit. It's not notarized. To quote Simon Dan, dear oh dear. And seriously, we have another affidavit of geez, and this one's it it is a different affidavit. Notice to principal is notice to agent. Notice to agent is notice to principal. Affidavit of truth and fact. Before me, the undersigned authority personally appeared. Diane, semicolon. Oh, it was a colon in the first affidavit. Killian Allen, who, being by me duly sworn, deposed as follows. Diane, colon, period. Killian dash Allen, a woman and a creation of God Almighty. Am over the age of consent. I am of sound mind and have personal knowledge of the matters stated herein. I have created this affidavit to establish the true facts in this matter. Geez, this is 17 pages. Never mind. If you guys want, I'm going to put a cork in it here. And we can come back later and do this affidavit as a separate video. Because I think I'm pushing 3 hours here. So, yeah, I think if you want, we'll do this as a separate video. Because it looks like it's going to be more sovereign citizen buffoonery. So, I'm guessing that her son, Chase Allen, who brought our attention to all this, I'm assuming he has filled out such affidavits in the past, and they weren't bulletproof armor for him. And I say that not as a joke. It didn't protect him. It didn't stop the police from pulling him over. It didn't stop them from deeming him a threat due to his alleged gun that was found on his seat. It didn't stop him from dying. I I mean, I broke down and like I actually did have tears in my eyes laughing at some points in this. But let's circle back to the start. This is deadly serious. It's deadly serious. That's why, like I said, prosecutors need to prosecute every single time. Police need to arrest every single time. No excuses. You've got to stamp this nonsense out and keep it from spreading. Any any semblance of victory by sovereign citizens allows it to spread. So prosecutors, police, sheriffs, US attorneys, no mercy. Got to put a stop to this. With that, like I said, I'm going to put in the public requests or public records requests this weekend. Hopefully, I'll have video for you of, well, some gory stuff for one and a traffic stop for the other. And with that, thanks for joining me. I will see you soon. If you haven't already, please like, share, subscribe, give me some comments on your way out, and I will see you next time. Thanks. Bye bye.